Hi, I'm Saeed, Los Angeles DUI attorney, and welcome to CBS Law, where we deliver results, not promises. I'd like to talk to you today about DUI cases. First, we'll talk about some of the most common DUI charges you can face. Second, we'll go over some defenses we successfully employ every day in DUI cases. And third, we'll go over some common sense measures you can take if you ever find yourself being arrested or investigated for driving under the influence. Far and away, the two most common DUI charges are often charged in tandem. I'll take them each one at a time. The first is a violation of Vehicle Code Section 23152A. This charge is often charged as a misdemeanor. What constitutes a violation of it? Were you driving a vehicle while under the influence of alcohol or drugs, unable to exercise the care and caution of a reasonable, sober person? This is often charged as a misdemeanor, and the maximum term of imprisonment one could face if you were convicted of a violation of Vehicle Code Section 23152A is 180 days in county jail at halftime. The second most common charge is a violation of Vehicle Code Section 23152, subdivision B. The elements of a violation of 23152B are: were you driving a vehicle under the influence of alcohol with a blood alcohol concentration of 0.08 or above? A little known fact: these charges are often charged together. The reason they're both charged is generally that first charge of 23152A, they're going to be looking for some evidence of bad driving. In other words, how you were unable to exercise the care and caution of a sober person. But in lots of DUI cases, there could be not much evidence of actual bad driving. Driving 70 miles per hour in a 65 mile per hour zone isn't necessarily indicative of driving without the exercise or care and caution of a sober person. So that B statute allows the prosecution to be able to point to a number and say, well, yeah, they may have been driving just fine, but their blood alcohol concentration was above a 0.08. Now, similarly to the A count, the B count carries a maximum jail sentence of 180 days at halftime, which means the most you can serve is 90 days of county jail. Now, if a person were to be convicted of both the A count and the B count, the max isn't 360 days. Rather, they merge and the max stays just 180 days of jail at halftime. Now, I'd like to talk to you about some common defenses that we successfully employ in DUI cases. First are constitutional issues. The police can't just pull over anyone. In order for the police to pull you over in your car or temporarily detain you, they need something called reasonable suspicion. That means enough facts where a reasonable officer could point to make a determination that a crime has either just occurred, is happening, or is about to occur. Often in DUI cases, we see that to be speeding, swerving within a lane, or not obeying a traffic sign. The second most common defense that we successfully employ in DUI cases is even if the police had the right to stop you in the first place, that does not give them the right to conduct a full-blown DUI investigation. Rather, the police have to develop additional facts that allow them to perform a DUI investigation. Generally, a DUI investigation involves field sobriety tests where they have you touch your nose or walk along a straight line, and then a breath or blood alcohol test in order to do a chemical analysis of your body. Now, a little known fact about those field sobriety tests is that they're voluntary. Now, the police won't tell you that, but you don't actually have to participate in any of those. The second little known fact about those field sobriety tests is there's no passing score. Even though they're called tests, you can only fail. The way they work is the police will have a checklist in front of them, and they're just going to mark off all the things you did wrong in regards to the instructions given on those field sobriety tests. Second, we're going to look to see whether the police had sufficient facts to allow them to start that DUI investigation. Often the police are going to look for things called objective symptoms of intoxication. That could be bloodshot, red, watery eyes, the smell of alcohol coming from your breath, slurred speech, or an unsteady gait. In other words, you're unsteady on your feet. The third common defense that we explore in DUI cases is looking at the handling of the breath or blood alcohol test. A blood alcohol test is a lot more complex than most people know. It involves really specific steps in regards to the taking of the blood, the storing of the blood, the preserving of the blood, and testing of the blood. And we utilize expert witnesses every step of the way to make sure that any test taken by the police, especially in regards to blood results, are handled properly. Because if they're not handled exactly according to regulation, that could add to doubts regarding the credibility of those test results. A little known fact as well about those breath or blood alcohol tests is you don't have to actually comply and give a breath or blood alcohol test. Now, there are some drawbacks to doing so. One of the biggest drawbacks is that the DMV, regardless of whether you get convicted or not, is going to suspend your license for 1 year, bar none. The advantage of it is you're robbing the prosecution of the ability to have a chemical analysis of your blood or of your body. Now, if you choose a blood test, there are some advantages there. First, you're going to buy yourself some time. The way blood alcohol concentration works is that your body is going to absorb and metabolize alcohol. The longer you wait, as you know, you sober up, the lower your blood alcohol concentration can be. The downside is, if you have any other substances in your blood, well, that's going to show up as well. Whereas with a breath test, it's obviously not going to show any other substances. Third, in certain situations, we also explore, is there any actual evidence of driving? One of the most overlooked elements of driving under the influence is the first part, the driving. If the police or anyone else didn't actually observe you driving, well, there may be an argument there that you actually weren't driving. And if they can't show you were driving, well, they can't convict you of driving under the influence. Now I'd like to talk to you about some common sense measures you can take if you or a loved one find yourself being arrested or investigated for driving under the influence. First, don't talk. Don't post online. Don't tell your friends. Don't advertise in any way that you were arrested while driving under the influence. Similarly, if the police ask you during a stop whether they have permission to search your car, and you know there's drugs or alcohol in your car, well, by all means, don't give them the permission. If they have the right to search, they will do it. If they don't have the right, then they're going to ask you. Now, far and away, the most important thing you can do if you or a loved one are arrested or being investigated for driving under the influence is do not delay in calling CBS Law. The prosecution, I assure you, is working on your case right now, and we need to get to work. So don't delay. Call CBS Law at 213-800-8005, and together we'll get your life back.